So I will read the posting of the hearing. It is a public hearing to consider ordinance number 4-22, an ordinance repealing and replacing in its entirety Chapter 170 Subdivision and Land Development Code, and amending Article 5 dimensional requirements, and Article 6 Historic Preservation Architectural Review Commission of Chapter 197 zoning of the Municipal Code of the City of Lewis, Delaware, by amending sections 197-50, cluster development, 197-57, jurisdiction and procedures, and 197-58, historic district or properties review process relating to subdivision and land development code. This rewrite of the subdivision code has been through a lot of work, and I want to thank the group from the Planning Commission who has worked diligently to come up with this revision, many days and hours and meetings to put this together. And we'll get into the discussion in just a moment, but I do want to thank you all for all the effort that you put into it. It's a yeoman's amount of work, and Nancy Stacy has chaired it, and the committee as a whole has worked very hard to come up with what we are going to review tonight. They have had public hearings also at the Planning Commission, and we're going to start off with a presentation by Nancy, where she's going to talk about what they've done and how they arrived at what they have, and then we'll get into questions from the table, and from there we'll go to questions from the audience. I understand from Kayla we have 10 people participating in the chat, and we'll get to those as well. So Nancy, the floor is yours if you'd like to bring us up to date. Thank you very much.
Thank you. And I think Kayla is bringing up the slides for everyone. As Ted said, I'm Nancy Stacy. I'm a member of the Lewis Planning Commission, and I chaired the LPC subcommittee that worked for many months on revisions to Chapter 170, the Subdivision and Land Development Code. The other members of the LPC, and maybe people can kind of stand up or raise their hand as I mention them, are Joe Hochner and Deborah Evalds. And also supporting the committee was our city planner, Janelle Cornwell, our city engineer, Charlie O'Donnell. I have to look around to see where you are, Charlie, and our city solicitor, Glenn Mandelis. We also had as our consultant, Tom West. Now, today, the mayor and city.
Oh, sorry, that's. I don't know what I did.
I know sometimes we need to repeat things, but on a 2-second delay. Okay. No problem. So today, the mayor and city council are soliciting public comments on these draft changes to 170. If we go to the next slide. Just want to give a little bit of the history of how we got here. In late 2020, the Lewis Planning Commission, or LPC as it's going to be listed on these charts, developed a list of action items to address. Think of it as a to-do list for the LPC to address outside of the normal LPC workload of reviewing applications. The list was long and it was sent to mayor and city council to get their input to set priorities. And providing that input, mayor and city council rated the review of the subdivision code as a high priority. Go to the next slide. And this led to the creation. Whoops. We're going to be going pretty quickly through these, Kayla, just so you know, you'll be jumping up and down a lot. So this led to the creation of a subcommittee to review the subdivision code and develop a draft set of proposed changes. The subcommittee has spent months on this, and we reviewed all sections of the subdivision code in detail and developed revisions. On November 23rd, 2021, we conducted a public workshop. And this was done at a very early stage to share our thoughts in terms of proposed changes and to solicit feedback. We received almost 100 comments during and after the workshop. And our subcommittee reviewed each and every one of those comments. And based on that feedback and discussion, we made many further revisions to the draft. On February 15th, the LPC conducted a public hearing to hear comments on the proposed changes to the subdivision code and received very positive feedback on the proposed changes. Following the hearing, the LPC then reviewed the whole, not just our subcommittee, but the Planning Commission as a whole, reviewed the draft and agreed on some additional edits and changes. And if you're looking at the attached packet that was on the agenda, these additional changes are listed under an update or under the update section on background for this hearing. So that brings us to today, where MCC is conducting this public hearing to hear your comments before considering enacting these changes. We go on to the next one. It's important, though, to note that the scope of what we were asked to look at was absolutely limited to Chapter 170 of the City Code. And this is the chapter on subdivision and land development. We're not looking at any areas covered in other chapters of the code. So this means that we're not looking at things like zoning that would cover things like the height, lot coverage, setbacks, et cetera, or the building code requirements, things like construction specifications, permit review, floodproofing, wetland buffers or floodplains, annexation decisions, and nothing that we are covering applies to existing subdivisions or to renovations on existing homes. So we're talking about new subdivisions when we're looking at this code. Go to the next slide. In conducting our review, we considered many factors, such as issues observed by the LPC when applying Chapter 170, areas of confusion, irrelevant requirements. We also considered consistency with the comprehensive plan. Transparency and simplification were also front of mind as we made revisions, and we considered the impacts of new technologies that were available. In making revisions, we looked at ways to provide feedback to applicants earlier in the process and to engage MCC earlier in the process.
That's the huge one, right?
Absolutely important, I think, yes. And I'll say a little bit more about why we thought that was so important.
Right.
We also consulted a wide variety of relevant resources and listened to feedback from the public, from builders, from developers, from experts in specific areas, and from the staff who work with these regulations on a day-to-day basis. I'll move to the next slide to look at our focus. So as we discussed Chapter 170, we placed a particular focus on making the process more user-friendly for everyone, provide greater transparency, eliminate wasteful requirements, for example, a large number of paper copies, which seem to be obsolete now, And updating, we also looked at updating the code to reflect new titles and terms, and expanding or adding standards and requirements as needed for things like open space, lighting, lot grading, etc. On to the next slide. Now let me cover a few caveats regarding these highlights, and it's important to keep these in mind. Like any summary, the slides that I'm about to present on highlights leave out some proposed changes. To review all of the changes really requires reading the whole draft code. And that's the only way you'll be able to make sure that you've covered everything. And I know it's long. Those in our committee know how long it is because we worked on it for months. Okay? But in an attempt to make it easier to review the proposed changes, we've attached to the agenda for this meeting a link to the current Code 170, Chapter 170, a packet containing background information, including some additional edits that came out of the review that was done by the LPC, and a copy of Chapter 70, that 170, the revised version. Now, I know typically when you're looking at revisions to the code, you often see the old version with things struck out and insertions, etc. Because of the level of reorganization that we did of this section and the number of changes, that was really unwieldy. And so we've given you the old copy and the new copy. But to make it easier to do that comparison, we've provided a table that lists the topics and where they're covered in the old code, and then what page numbers or sections they're covered in the new code. So if you're particularly interested in lighting, for example, you can read the old and read the new more easily. We also included a table indicating how the 22 factors for review that were listed in a separate section of the old code have been integrated and covered in the current code. So all of this is in the packet that's attached. Go to the next slide. I have to say, it's very difficult looking both at our city council and at everyone here.
It's okay, go ahead.
When I'm facing a
It's a
wall,
public hearing.
basically. Okay. I feel like I'm watching a game of tennis
pong,
or something, yeah. So what I want to do now is briefly review the proposed changes to the process. One of the key changes we're proposing is a change in the overall process, the overall application process. So first, let's look at what the current process is, and it's on the slide here. It begins with the submission of an application. City staff then review and prepare reports and comments on that application. Next, the Planning Commission confirms the reports and holds a public hearing, then reaches a decision on recommending approval, approval with conditions, or denial of what we call preliminary consent in the current code. The applicant then seeks agency approvals with after preliminary consent. The application is reviewed again by the LPC and then sent to mayor and city council. Or on our slides, I just refer to this as MCC as a shorthand. And they review it, and then another public hearing is held. The MCC then makes a final decision and can reject or approve the application, or can add or change any of the conditions placed on the application. Now, we've identified several problems with that process and are trying to address these in the revision of the code. First, there can be some cycling, and there's a lot of frustration at those early stages if the applicant misunderstands or overlooks some requirements. Homeowners within 100 feet are notified when the application first arrives. But at that point, there's often little to share with them, aside from the fact that an application is in process. There's no meeting date has been sent. The application is often so incomplete that there's little for anyone to review. And this leads to a lot of frustrations on all sides of people trying to seek information. And I should say consent is not really we didn't feel that consent was really an accurate title for the first column, because it's often misconstrued to mean that the LPC has granted some type of permission, which is not the case. It's only saying that the application can move forward into the next stage. When an application first reaches MCC, the applicant has already gotten agency approvals. Now, if MCC adds or modifies any of the conditions, this can potentially require the applicant to go back and get all of those approvals all over again, and again, adding more frustration. So let's look at the proposed new process. We'll go to the next slide, Kayla. We've tried to address these issues in the new process while ensuring that the same number of public hearings are still required. So there's still the same level of input and involvement from the public. Under the new proposed process, we propose to change the name of the first stage from preliminary consent to preliminary review, because we think that really reflects more what that first stage is. Second, we are suggesting that we require a pre-application meeting with city staff to ensure that all requirements are understood and to answer any questions about the overall process. And an application would move forward to the LPC. And now I'm going to read, and this is now in quotations, this is what, when the LPC reviewed this, we think should be added to the draft that's currently there. That it should move forward once the city planner verifies that the application complies with the application checklists and is in sufficient form for further review. And this would be correcting wording that's in there currently. It basically says that the city planner would move it forward after they determine that it complies with the code. Because we think the decisions about compliance with the code would be made by the overall planning commission and is not a, simply a desk activity at that point. Third, we are suggesting that we offer an optional pre-submittal meeting with the LPC to discuss conceptual plans. And I'll go into what that meeting would be like in a little more detail in the next slide. Next, there would be a presentation of the application to the LPC, followed by a public hearing. The LPC would then make a recommendation to the MCC, who would hold a public hearing, and then reach their decision on the preliminary plan, modifying or adding conditions as they see fit. Note that under the new process, both the LPC and the MCC review the application at the preliminary stage and have a chance to put conditions on it before agency approvals are sought.
Now that's new.
That's right.
Right,
Yeah.
it's a change.
That's a big change.
Yeah. And after agency approvals are obtained, the application would come back to MCC for a final review and a final decision. Now let's go to the next slide. Just want to go into a little more detail because initially when we presented this, there were a lot of questions about what this conceptual review would look like or would be. As I've mentioned, we've suggested of adding this as an option to applicants. It's not a requirement, it's an option. And the applicant could request a conceptual review with the LPC. This would be held at a public meeting and would be an opportunity for the applicant to receive some feedback from the LPC at an early stage. But this would not be a hearing with public comments. And the Planning Commission would not take any action or to approve or deny the concept or any details of the proposed development at the project concept review stage and discussion. But it
So
would
is this,
provide
is this simply
feedback.
clarification for the individuals?
Yes.
Okay.
And it gives them, it would give them some initial feedback on the overall plan, because once people have gone through the time and expense
Right.
of making a very
Right.
detailed plan, it becomes harder to shift anything in
okay.
it.
Got it.
We'll go on to the next slide. As we go through the highlights of changes, you may notice some page numbers on these slides in blue. These correspond to the pages in the draft code where the topic appears. And there are two versions of the draft code that have been posted. One has line numbers on it, which shifted the pagination. This is the clean, these are the page numbers on what I call the clean copy. And if you're looking in the packet at the bottom of the page, there'll be two page numbers. There'll be a page number for the page it is in the packet. This refers to the page number in the actual document. Now, Other changes to the process include standardizing the public notification requirements to make it a requirement not at the time of application, but at the time of public meeting or hearing. So this would require a notice to be posted on the property and in the paper 15 days before any public hearing or meeting, and a letter to property owners within 100 feet 15 days before the hearing or meeting. It also requires that the applicant materials to be reviewed be submitted and posted 15 days before the hearing. And this was in response to members of the public feeling that often some things would be modified or posted in just a day or so before a meeting.
Nancy, what is your expectation with respect to what qualifies as a posting?
I mean, it would.
So-
looking at it, it's-
So as we talked about it, they need to submit everything to the planning office 15 days before, so staff can verify, and then typically everything gets posted. So the agenda gets posted 7 days, but they have to get it submitted 15 days before the hearing date. So I can verify, or staff can verify that everything's in compliance with, so it can move forward. And then typically everything in the packet then gets posted that 7 days when the agenda gets posted.
And the actual contents of the packet are stated in the code.
I understand.
So, yeah.
I understand. But I want to make sure that we have an understanding, or I'd like to have an understanding that the packet, that is all the material that the developer has provided, is in fact embedded in the hearing notice,
Yes.
not just on a website, but actually posted and included in the hearing.
So it'll be on the agenda.
That's
Or
correct,
it'll
the
be, there
agenda.
will be a link from the agenda to the webpage that
Correct.
contains the application, because all the applications have their own individual webpage. So that information was there. It will not be there 15 days beforehand because it's
No.
due 15 days.
I
So
understand.
that gives me some time to actually verify everything and then get it up onto the website.
Correct.
So it's ready to go when the agenda has to be posted 7
Correct,
days
but it
prior.
will be embedded in that agenda when it's
Yeah.
posted 7 days
days.
prior.
Yeah, or at least the link will be to that webpage. Yes.
Yes, that's all
Yeah.
I'm
Yep.
expecting.
Yeah.
Thank you.
Nancy, just one other point while we're backing up just a little bit on the preliminary review. All of those meetings would be public meetings.
Yes.
So that somebody didn't feel as though that a preliminary review by the planning commission before it was actually submitted,
Yes,
but it would still be a public,
absolutely.
a
Yes.
fully exposed
Yes.
public meeting. Okay, thank you.
Yeah, the only meeting that's not a public meeting is that initial meeting that they have with city staff
Right.
to explain,
Right.
what has to be submitted, et cetera.
Right.
That's fine.
Then additional changes are to allow up to 2 6-month and 1 year extension for cause, and we define what cause is. Update the levels of insurance required, and change the focus of enforcement from a criminal penalty to a civil assessment. Go on to the next slide. So we've provided a summary list of the major subdivision preliminary plan requirements and a summary of the requirements of what has to be included in a major subdivision plan as exhibits A and B in the draft code. And these provide a more user-friendly way for applicants to review all of the requirements for each plan, as opposed to having to, find them interspersed throughout the whole code. The proposed new subdivision code also expands and provides more details clarifying requirements for a variety of review items, such as details on impervious surfaces, lighting plans, et cetera. The plan is to provide an online application materials once the code is finalized. Go on to the next slide. We've clarified in the proposed code that conditions can be recommended and placed on approval of a minor subdivision. And while almost everything else I'm covering today, it is in reference to major subdivisions.
Right.
I think everyone always believed this was possible. We wanted to make sure it was clearly spelled out in the code
Right.
in terms of minor subdivisions. And we've updated the titles of city staff and committees and made revisions to the joint site ad hoc review committee that it be appointed in June of each year for a 6-month term.
Right.
I'll go on to the next. Now let's move on to the proposed changes to the design standards and definitions. We're proposing to clarify and update the requirements sections of the code. And many people are familiar with this list of 22 factors that the LPC is to consider in reviewing subdivision applications. And this occurred in the old code as this kind of list of 22 things. What we've done is we've pulled these out of the old code and incorporated all but 2 of them into new revised, more detailed standards. The 2 we didn't include are number 21, job creation, because we didn't think that was just really applicable in this section. And number 19, whether the estimated expense to the city can be justified. And again, we didn't include that because we saw it as more relevant to annexation as opposed to the construction of major subdivisions. We've attached in the agenda a table that provides a crosswalk of those factors. So there's a particular factor that you're always focusing on. You can find out what pages in the code we detail that factor.
That's good.
Next slide. One of the big organizational changes we're recommending involves reorganizing and revising Article 4, which contains the design standards. And we're reorganizing this under a consistent series of headings for each category of design issues. So for each category, the requirements are described in terms of first intent, which describes the purpose for each category. Intent statements are to be used by the LPC during preliminary review to advise. Then standards, these are provisions that apply to most applications and are required to be met. They're phrased as shall. Some provisions include a list of options that could be used to satisfy a given requirement. And then there's a third category, and these are guidelines. These are provisions that should be considered, but may not apply to all proposals. And as part of the review process, applicants are required to consider the provisions, these provisions. If applicable, these guidelines can be applied as conditions for approval. On to the next slide. Now I want to go over at a high level some of the specific changes we're proposing to the subdivision design standards and guidelines. On some of these slides, there are a lot of words, okay, and I'm going to call out just a few topics on each of them. So we've tried to show the page number in blue indicating where in the draft you can find each topic if there's something you're interested in. So beginning with site design and site suitability. Examples of changes proposed in the site design include orienting buildings towards the street or common areas, ensuring the design respects privacy and solar access, and setting a proposed setback from the front of the building of 5 feet for garages. Examples of changes in site suitability include lot layout and building placement to minimize impact on natural and historic features, wetlands, and/or floodplains. Next slide. The lighting section has been expanded given the many changes that we see in technology and basically changes in our knowledge regarding lighting since the code was last revised. Proposed changes include setting revised standards for a required lighting plan for subdivisions, adding standards for residential lighting of 2,700 Kelvin and for commercial of 3,000 Kelvin, and establishing requirements for light sources and placement. And here we're balancing and trying to ensure safety and efficiency while limiting the glare to adjacent properties and the disruption to natural habitats and the nighttime sky.
Good.
Next slide. In the landscaping area, key changes include clarifying and increasing the requirements to be addressed in a landscaping plan, setting more specific criteria for street trees and buffer plantings, focusing on native species, requiring a site distance for plantings at intersections, and requiring residential buffers to be included in open space and not located on individual lots, which has caused some confusion for
excellent.
homeowners.
Yes.
Next slide. Regarding open space, we've defined types of open space and set requirements for 20% open space, with at least 40% being contiguous, 20% of it being community space, 60% being usable, and 20% maximum impervious coverage. Areas such as parking areas and water management facilities would be excluded from open space.
That's a significant
To
change.
provide some flexibility, relief from the provision may be granted by the LPC for projects with more than 30% of open space and using green technology, stormwater best management practices graded into the natural terrain to provide space that can be used for recreation while addressing stormwater issues. Consideration is also to be given to preserving large trees, natural and historic features, and creating central community spaces. Next slide. I'm going to go through these fairly quickly because there's a lot of information and I know people are here to provide their comments and input. We've proposed revisions to the street regulations to minimize speed limits, street lengths, and street widths, encourage permeable pavement systems and interconnection with adjacent streets and neighborhoods, address on-street parking while minimizing street widths, and promote the increased use of pedestrian and bicycle movement, as well as encouraging consideration of transit services, EV charging stations, and pullover space for shared vehicles. Next slide. In terms of water utility, the revisions focus on ensuring that proposed water system facilities are adequate to serve the subdivision and adjacent BPW service areas. Next slide. The focus of the sewer design revisions are on ensuring that the sewers are adequate for all existing and future users of the development sewer infrastructure and the upgrading of existing downstream sewer infrastructure to collect and process the additional flows from the proposed development. Next slide. Proposed improvements to the stormwater code include a more conclusive design approach during the preliminary review phase, the addition of standards to review the design and installation of individual lot grading plans, and a general updating of stormwater infrastructure standards. On to electricity. In the electric utility and the section 170-32 other utilities section, the focus is on general improvement to the electrical and other utility codes and requirements to consider sea level rise in critical infrastructure. Now, based on the sections of the code proposed for revision, we've added many definitions to the chapter. Now, and these are all listed here. So we have a whole series in terms of lighting, such as what adequately shielded means, full cutoff, et cetera, to open space. And I mentioned the different types of open space: green space, open space community, open space permanent, and open space usable. Lot and lot grading, landscaping, streets, and other things like green technology, stormwater management practices, preliminary review, and site distance. And then we've added from other sections of the code definitions that we thought needed to be in this section for things like block building, building setback line, et cetera. And we've edited definitions for things like the application development application fee development, and added a reference to the online application and added reference to the Joint Site Development Committee. So this brings us to the end of the very quick walkthrough of what is in the revised code. Thank you very much.
Thank you
Thank
very
you.
much, Nancy, for a very nice comprehensive review of what you all have been working on for literally well over a year. And thank you. I would note that we have received 3 public comments so far, one from the BPW and 2 from private individuals and also from the HPAR. So those were part of the record. You've already put them up, I believe, correct,
Yes.
Janelle? Okay. So I think before we get into public comment, are there questions or comments from the table?
I had,
Yeah.
go right ahead. I had a couple of questions that I asked Nancy and I wrote them out to make sure that she, we fully understand it. Within the earlier input period, would mayor and the city council have the opportunity to require additional third-party independent studies regarding impacts on the neighboring homes?
Yes,
Okay.
you have that now, and that continues to go forward with the proposed ordinance.
Okay. In the past, we've had to depend on the studies already submitted. So with our involvement at the earlier stage, if we believe what the developer describes initially signals some kind of a problem, do we, will be able to require studies and new studies maybe?
Yes.
Okay, good.
Yeah, you can make that a condition of approval. Again, that's why bringing the mayor and city council much
Right.
earlier into the process.
Mhm.
I think the code actually says within 60 days of planning commission making a recommendation, you getting their report, you need to hold a public hearing. So you much earlier in the process.
Well, I think that's extremely critical because I
Um,
remember when we first came on, oh, I can only speak for myself when I first came on the council, that there was something before us. It had all been signed, sealed and delivered. And I went to Glenn and I said to him, well, is there something that we can do? You know, it was so far ahead of us. So I appreciate the fact that we now have an opportunity to see much of this before it gets that far down the pike.
Yeah,
So
this
thank
would
you.
give you the opportunity to ask for more additional information, place additional conditions on the application before it moves
Mhm.
forward.
Yeah, the more tools and guardrails we have, the better off we are.
Yes.
Yeah.
Thank you very much. I appreciate that.
Okay. Who would like- Julio?
I have a comment and a question. And so, first of all, thank you, Nancy, for all the work you and your team, as the mayor had mentioned. This is a lot of work. I mean, I'm looking through this and I've read through it before and it's all underlined. So we're basically replacing 170.
Absolutely.
And which is quite a task. But for me and others who are listening, I mean, can you just summarize quickly what your objective was throughout all this process?
Yes, and you know, keep in mind, this whole process began because the LPC saw that there were challenges in terms of applying the current code.
Right.
And saw the frustration both in applicants and the frustration of the public in the way the code the code is written.
Fair.
And it began because mayor and city council agreed and set that as a high priority. So that's what started it. But our objectives were to simplify things, to make sure there was real clarity around what is required in terms of standards,
Mhm.
and then what are guidelines that provide an early kind of identification even for applicants of the things that they need to consider that could be made as conditions. And we also felt that we really needed to update a whole series of sections, that there've been
Mhm.
changes in technology, changes in just our knowledge of things, and that was important to do. But the change in the process, so if you think of it, there's a whole set of changes in the process, and those were directed at making sure that mayor and city council and the LPC get to look at these at a stage where there can be influence and where there's where the applicant can have an early identification of
Mhm.
conditions or things that need to be done, whether it's an additional study or conditions that are going to be placed on it.
Mm.
The changes in the code really focused on making sure that differentiation between intent, standards, and guidelines is clear, and that we updated the standards to provide a lot of clarity around what actually needs to be done, that we don't have, I don't want to say kind of motherhoody statements that
Mhm.
it's hard to,
Mhm.
it may be in the eye of the beholder, whether you're complying with it or not. We wanted to make things very explicit.
I think also the intent was to make sure that the applicant got much earlier feedback.
Yes,
so that-
exactly.
Because I think that's one of the things that that both council and the planning commission felt was that it was going along so far
Mhm.
before there was actually feedback opportunity to the applicant.
It's interesting because in a sense, everyone involved in this process felt some frustration that
Mhm.
everything came to them too late.
Mhm.
Right?
Absolutely.
Feedback to the applicant in terms of conditions, you know, where it's too late. Input from MCC was too late.
Mhm.
And even at the LPC level, there's this sense that folks were arriving thinking that they'd already gotten some approval of something when it was,
Right.
you know,
Hadn't
wasn't the
been-
case.
Yeah.
So I also noticed in some of the rewrite, there was a consideration given for solar access,
Mhm.
which I noticed. And I was wondering why solar, which is terrific, but why wind, for example? I mean, I've noticed in a lot of other communities, there's smaller wind turbines that can be placed upon homes, garages and others. I mean, very miniature, but have become almost standard in some places, also for businesses as well. And why solar was singled out as opposed to just general renewables?
So the zoning code actually currently has a section that deals with
Solar.
wind. So that's actually in the zoning code that
So that's already
addresses.
there.
Yeah.
It's already in a code, so I think it might focus a little bit on the larger scale, but it does allow for wind in the existing chapter 197 zoning, and
Right.
Charlie's got his hand up.
Industrial.
I think sometimes where it says solar access, it's more about access to the actual sun, not for
Solar
Not the
panels.
panels.
aesthetic purposes,
Yeah.
yeah.
Oh, not
or-
paneling.
It's
Yeah, not
siting
so
of the
much the
house.
solar
Yeah.
energy. I
Yeah.
think that might be the case.
I think we're using the term as a general term that would, I mean, if you have access to the sun, you potentially have access to put a panel somewhere, but you can also have access to the sun just for your pleasure and enjoyment on your property.
But that wouldn't exclude someone who wanted to have a miniature wind turbine.
No, there's a
That's-
different.
That's a whole different.
That's a different-
197 in the zoning code addresses wind opportunities for people.
Okay,
Hmm.
thank you.
Good catch, though. I mean,
So I have a couple comments and a couple questions. First of all, again, thank you for the hard work and it's, as Khalil mentioned, it's quite comprehensive change. So first, my comment is, I think some reached out and there was some difficulty finding some of the materials attached to tonight's hearing, particularly on the agenda for tonight's calendar. So for that, I apologize. Hopefully others were able to find it through previous workshops and our March meeting and or April meeting rather. The other comment I have is because it's so comprehensive going forward, do you have thoughts around maybe a way that we could dissect this as a council and take it in pieces, one for consideration for the public, because it can get as you said, it could get unwieldy. So I wonder if you had a thought on that in terms of sections that we might take on in bits and examine them for, a comprehensive overview of it. So that's one of my first questions. Then I have another if you want to comment on that.
but I mean, in a sense, the code is organized. In a sense, one of the other things we did in reorganizing this was to have topics covered all together in sections where at times things were split up a bit. So I think it should make it easier to digest because when you go to the lighting section, everything except the definitions that would be in definitions, everything about lighting is there.
Right.
The
So-
other thing, Nancy, that you mentioned when we talked earlier today is when the planning commission had your public hearing on this, you broke it into comments. One, first about the process that's set forth under the new proposal, and then separately the standards and guidelines so that you can look at,
Each one.
the process and then the substance of what's required.
And then an overall comment, just in terms of changes, when people go for their approvals, I noticed in reading it that we still are relying on the Sussex Conservation District. And,
Yes, we are.
You brought up the idea of sea level rise, and as far as I understand, that's not something they're really factoring in when they do things like that. So again, I wonder, if this is potentially a comment for Glenn, is if that's an intent of us as a community, how do we strengthen that if we're still going to rely on SCD?
Yeah, I mean, I suppose there's provisions that could be written, because the general rule now, pretty much SCD approval is one of the approvals that's required, but as you say, I'm not so sure it goes as far as the city would like to see it go. Anne Marie's.
Well, how do you
Well, the
replace it?
issue is it's all under the state sediment and stormwater regulations. So we would have to consult with DENREC to even get a delegated authority to be able to do our own sediment and stormwater and have a different standard. So we could have that conversation with DENREC. But they ultimately determine who they will delegate stormwater enforcement responsibilities to.
And for clarity purposes, they have delegated that to the Sussex Conservation
Correct.
Right,
District.
exactly,
Correct.
exactly.
So
That's
they're, okay.
It's
They're-
like going
they're-
around in a
they're
circle. It's
considered
the
And they
same.
have a similar
Right, and-
group for Kent County, Sussex County as well. I mean,
Yes,
Yes, the
Newcastle.
Newcastle County, the
Right.
county has the jurisdiction. And I think Newark has its jurisdiction. So there are different, I mean, there
There's
are some
two.
municipalities. The town of Middletown is a delegated agency, so it's possible. But even in those cases, it's all being operated under the state sediment and
Mhm.
stormwater regulations.
Right.
So if we wanted to develop regulations that exceed the state sediment and stormwater regulations, that would be, I think, a whole separate process.
And I think there's also a different way to look at sea level rise. I know with the resiliency committee, they provided some options, and there was a big list of 14 items that, it could also be, if council wanted to take a deeper look beyond the two that were recommended action on, they could look at that for additional ways to address sea level rise than just in stormwater management. I think there's across the board a number of different ways to look at how the city could address sea level rise.
Hmm. But we really have to stick with SCD, right?
Oh, yeah.
That's not what
To answer
Yeah,
Andrew's
that's-
question, I
did you
might
say
say, let's hold off because MDE in Maryland is already beginning to address so many of like the 10-year, the 25-year, the 100-year storm are based on historical statistics. And MDE is in the process of updating all that data. And DNREC always, in the past, is in lockstep with MDE. So I guess I would recommend that maybe we can hold off a little bit before we take on a whole lot of responsibility with a separate store. I think we've really strengthened our stormwater management section by noting and requiring like green practices, and then the preliminary meetings with SED and the feedback given back to staff and planning commission and council way ahead of what we used to do. So I think we've really strengthened it, but I think I would advise maybe hold off on like really making big changes to what the city would take on as responsibility until we see how this plays out.
Took that on, you would also be obligating the city to pay for it,
Mhm.
or the developer.
Yes. Yeah.
Charlie, when you say wait till we see how it plays out, are you talking about chapter 170, once we get these revisions in place, if this is supposed to be approved? What are you talking about?
So MDE is in the process of
Okay,
updating
you're
their
talking
whole
about the Maryland.
stormwater management.
Okay.
Yeah, and I've been around for a long time now, and MDE is always a little bit in front of DNREC, but
I
they run in
understand that
lockstep
part.
with each other.
Okay, so are you saying like
Mm.
2 to 3 years, we might need to?
Yeah.
Is that how long?
Yeah, I would think, yeah, that would, because they started this process, first time I heard about it was probably 9 months ago in Maryland.
So they're probably, yeah.
But we as a committee only looked at things that were already within what we understood to be our current level, the current level of delegation. So-
Right,
Right.
Right.
Did you have questions?
The only question I have is a process related question, and it has to do with the fact that I've read through the entire document and I've highlighted the document and I have a lot of notes, and I don't understand how we're going to.
That's kind of what I
Get
was
to
getting at, the
that.
process. So
Right.
How do you want
And-
us to bucket or comment, comments coming? in?
Exactly, and from the public too, hopefully they're well prepared to have conversations as well. So I'm looking forward to being told how we're gonna go through the document itself, the chapter 170.
Well, I have to say, I think coming into this, our understanding of the process was that, we have our workshop, the hearings, you have this hearing, and then it's kind of over to city council.
Mhm.
Now, it's, in a sense, the ball is in your court, if you want kind of our advice or opinion on how to digest it, I guess. I would suggest doing what we did as a committee, which
Just
is,
breaking it.
going through it section by section as city council, sharing changes that you think should be made or, but first, I
That's
think
what you do.
the first order is to hear
From the public.
from the public
Sure.
on additional things.
Sure.
And, as a subcommittee, we'd be happy to answer any questions that you might have, or if you want some explanation of why, other things we considered or why we may have gone in one direction versus another, we could certainly provide that kind of input and insight.
Good.
Huh, okay, thank you. Nancy.
One question about your site design, when you said you revised and expanded, consolidated the standards, and you used examples like orientation towards the street and then the solar component that we talked about. Did you also look at established building lines in terms of amounts of setback or how far something could be set back on a property?
No, because that's in a different section of the code.
That's what I thought, but
Yeah.
I know that we've
And-
heard that issue
Yeah.
raised several times,
Mhm.
and if you're looking at a subdivision, those kinds of issues may not be there may not be an established building
Yeah.
line, and so we may want to think about that, or at least look carefully at the established building line section.
And I should say one thing that came up, because, we've gone, as a committee, we've gone through a lot of discussions, and through the workshop and hearing, we have had a lot of discussions. We are also in the process of forming a list of items that came up that we felt weren't in scope, but seemed to be related, or are items that city
They did.
council may want to look at.
Okay, great, thank you. All right, so I think we now then, if unless there are other questions from the table, I think we're ready to hear from the public. Anyone would like to step forward, and we'll also be entertaining questions from the chat. So if you have a question, if you type that in, or we can elevate you and you can ask your question in person. And we'd ask that you come forward to the podium, identify yourself and your address so that we have it for the record. And we'd ask you to limit your question to 3 minutes or your comment to 3 minutes if at all possible. So the floor is open and we'd like to hear from the public. Yes, come on up.
Good evening. I'm Barbara Curtis, 17 Ship Carpenter Square. First, I'd like to thank you for all the work you've done. It sounds like the process improvement is tremendous and will make a big difference to people. But I did not read all 125 pages yet. I'm used to reviewing documents either side by side or redlined.
Right.
And I didn't want to print all those pages to compare the two. And I did notice when I was looking through the beginning sections that a lot of the beginning is exactly the same, but with additions. And it would have been helpful if those weren't underlined, or something, some way to tell easily where you should switch your screen to another whatever, but I'm sure you've heard that before. So one thing I did look at in depth were the definitions, and also see the section on compliance 170-5. And this one surprised me to see that it was in the old code and is also in the new code. That the code, this chapter 170, does not apply to any land which the city owns. So that means the code doesn't apply once you get across the canal. So what applies to all that land over there? Does the city have its own requirements, or can it impose any requirements it wants? I mean, if that's not what's intended, then I think that should be modified.
Well,
Glenn, is that something, I mean, I guess.
That's a really good comment.
Yeah, because we don't
Yeah.
consider
City doesn't own
that
and control
city
it. Yeah.
owned, but.
yeah, we
but-
consider, it's
Yeah.
leased land to
Yeah.
the,
Right.
Right.
to the property
So-
owner.
Right.
You're talking about sentence C, is that correct,
Correct.
Barbara?
Um,
Mrs. Curtis?
I thought it was E,
Oh,
170-5
E.
E.
Yes, it is E.
Yeah.
Mhm.
oh, yes,
Yeah,
okay.
well, I think the piece which, for which the city is the lessee is the question you're asking.
Mhm.
And that may need some clarification.
Well, they're the lessor, aren't they?
Right.
Or-
We're the
Yeah,
lessor
we're the
and we're
lessor,
also-
but,
Yeah.
you know,
Lessor,
but
yeah.
Yeah, no, it's all. the
It's
land
all,
on the-
it's all land, yes, right.
Okay, that was the first one. The other one, well, there are a few. Commencement or starting of construction is in the definition section. It's on page
Mhm.
5. That wasn't completely clear to me, whether it's not
Right.
just that the people and the materials are there, and therefore, construction has commenced. Or do the roads or something have to be installed, completely installed? You know, it's not,
Right,
yeah,
I'm sorry.
that's a possible loophole in there that could
Okay.
bear fixing, or a source of confusion. The next one is really a social justice issue, and I understand it was taken over from another part of the code, the dwelling unit definition, where it talks about exclusive use, this is page 6, exclusive use of a single family maintaining a household. So if you have 2 friends, they can't have a dwelling unit. You know, that's not today. Or an unmarried couple or whatever.
Mhm.
And family isn't defined. I don't know if it would help to define family, maybe not, but
Right.
I
That's a whole
prefer.
other can of worms.
Yes, yes.
That's right.
And then I looked on page 7 on definition of height, and I'm guessing that was taken from somewhere else or new, but it was totally incomprehensible to me. So I don't know if others will have problems with that. Others who are not engineers or something, you know,
Right.
the center line of the house and the center line of the street and.
Right.
Okay.
That has been in the code for a long time.
Curious.
That is that's a lift right out of the existing code.
Yeah.
Full disclosure, I had nothing to do with that.
But if you're looking for clarity.
Yeah.
Yeah,
That would be one area I
Yeah.
think we could
Good one.
use.
yeah, well, it would also be a good one
Yeah,
to,
That actually
That's
goes,
one that we took from other areas of the code.
I thought,
So
yeah.
to change the definition there would require,
Changing the code in multiple other places.
yeah.
Yes.
That's actually on one of the, I think that was looking at holistically a lot of the definitions in their entirety, as part of something the subdivision code was gonna look at, to bring forward, because we noticed, it's like, we didn't want to start changing one code and then we'd have to fix it in a couple other
Correct.
places.
So- So-
So-
Isn't it written at this point so that the definitions in the subdivision and the definitions in the
Zoning
zoning are the
match.
same, so they're not
Correct.
in
Yes.
conflict?
Yes.
Because
Yes.
that tends to happen too.
So that's
Um,
why
Mhm.
they are the same, because we didn't want to start messing.
With the
It-
zoning.
Yeah.
It's on the list Nancy mentioned that we need to take a look
Yeah.
at,
Yes.
because we knew there were things that needed to take a look at, but we didn't want to start. It was a bigger project than just the subdivision code.
okay.
Okay, then on pages 9 and 10, where you have the definitions for open space and open space permanent.
Mhm.
Mhm.
They both claim to be permanent, but the second, the open space, comma, permanent, has legal protection. Does that mean the first open space could later be developed? That's a little scary that you have a need for 2 different kinds of open space that are both permanent.
That certainly wasn't the intention. I think the intention was to. Look at these again in detail.
I think the important thing is that when open space, the term open space is used a lot of times where it's not permanent open space in the terminology. So I think the important thing is the way, anytime you see open space in the context of the subdivision code, it means a portion of the development site that is permanently set aside. So I think it's more that there are many instances where the words open space will appear without the word permanent in front of it, and you need to have,
Yeah, and currently the code doesn't actually have a definition of open space, it's open areas. So we created the open space to be more specific than what is an open area. then versus the open space that is the 20% area land that is required in a major subdivision.
And then you also add the standards for what open
Space
space is
can-
required in addition to the definition.
And
I
what
think
can
it actually-
and cannot happen on that open space.
Will not be developed.
Yeah, so we got really specific with that one.
I
So,
wondered.
mean, in a sense, though.
Yeah.
The first, we have a definition of open areas because that's what had been used before.
Mhm.
And we added open space. And in that, we say that a portion of the development site that is permanently set aside. Okay, so that the intention there was to describe open space as being permanent.
Mhm.
It may be redundant to say open space permanent because
Right.
all of the other open spaces, because they contain the word open space,
Would seem like it is.
were
Mhm.
intended to be permanent.
Yeah.
So just, I think that's maybe something that should be cleaned up when.
Right.
My
Okay.
recollection of when that was put in, and I'm sorry, we probably shouldn't be debating this, it's more about hearing from the public, but open space permanent was a term that was inserted several years ago. And when it says by legal means by legal means, it meant that there was something more than just being zoned permanent
Correct.
space. So for example, there's a deed restriction that says it can never be developed or something like that. Some additional-
Well, I think honestly, I think it goes back to the canal frontage
Yeah.
along Pilot Town Road, that was all zoned open space permanent. It could not be built upon in any way, shape or form, whether it was however. So I believe that is where the history is.
So how does that align with on Lewis Beach where they have the former paper streets that are now open space? Are they also permanent open space?
Or are they open areas?
Well, they have the zoning designation of open space, so they have that protection, but you as a city council
Have not made
put a
permanent.
public hearing together and zone it something else.
So we could.
We could make it open
theoretically
space
Come
permanent.
back and say, oh, we're
Or
gonna
make it open space
revoke that
community.
open space and declare it.
Yeah,
you
you
know.
could do something else with it.
Yeah.
Right.
This is why we
It-
didn't want to go into how to fix the definitions. We just wanted to add the new ones because as you can tell,
Yeah, there's a lot of.
there's,
Yeah.
we could spend another year just talking about definitions, hopefully not that long,
Right.
but yeah,
Yeah,
we
but to
know,
Bar- to-
we
to
know we've
Barbara's
got,
point, words
to
have
look
meaning.
at it.
I mean,
Right.
Absolutely.
Yes, they do.
Yeah.
so I
They
think this
do.
is a important part, one of the, probably the most important part of the process, and we're getting more specificity around what we mean.
What might help, and obviously this can't be done tonight, is and we could do this at the staff level, is we could do a search for the terms permanent open space and open space and make sure that the definitions are, that the terms are applied the way the definition's intended, so that there's no, I think that's what's most important when you're looking at definitions in the code.
Right.
that
What's the intent?
Context of the language and the
Right.
definition are what is
Yeah.
intended.
But it's also, those definitions are going to be used by applicants, by developers when they make their proposals.
Right.
So it's really critical that the definition of the term is very clear.
That's what they're saying.
And
Right, but
What-
that's,
what you're
and
saying.
looking
Yeah.
at how it's used in the text, we need
Right.
to- we
correct.
don't want to say open space somewhere and not mean
Open space
Right.
permanent.
that, whatever
Yeah.
that
Yeah.
says.
Yeah, the one question I had about open space and what is omitted here was, there's no definite, does it include recreational area?
It says open space usable.
Yeah, it's in,
The community and the usable.
yes.
Yeah,
It's a
so.
usable.
That's what,
and- but
that was
usable
encompassed for that.
is-
Well, it's defined.
Well, I
Active or
didn't
passive
see-
It says open
recreation.
space may be used as a
Next page.
community,
Yeah.
I understand.
open space. I know
But,
you
you
understand,
know,
but that's what
community-
it
Did I
says.
see this?
Yeah, I read
Okay,
it all.
okay,
Right,
all right.
right.
And-
That's usable. That's a different definition than open space. Right,
Well, open space as a term we
Correct.
defined, and open space didn't appear in the code before.
right.
So we felt that we couldn't redefine open area because it appears in many other sections of the code.
Correct.
And if we defined it differently,
We had
we're
to change
suddenly
everything.
rewriting,
Yep.
this,
Yep.
the zoning code, this code, and so we added the term open space specifically in, for subdevelopments. And we defined the term open space, then defined different categories of open
Right.
space. So open space is something I can go through the definition. is a portion of a development site that is permanently set aside for public or private use and will not be developed. Open space may be used as community open space or preserved as green space. So then we go through what is community open space,
Right.
what is green space, and go through definitions of those.
Right.
But the word open space appears in there, and the definition of open space carries over to those definitions.
So then the question just is, do you need 2 open spaces? in
Well,
the
it's got
definition?
actually 4 in here right now.
Yeah.
Yeah.
Well,
So-
no, yeah, okay.
But that's also because you use those terms and you want to convey the difference
Mhm.
between the community open space, the usable
Yeah.
open space.
Yeah, so in the open space section of a subdivision, it actually references all of those categories of this amount has to be community open space, this is permanent open space, and this is usable open space, and it does reference these definitions in that section of the code.
And
Right.
we were trying to recognize that there's some open space that you enjoy simply by looking at it.
Right.
It may not be usable, but it's pleasant and it adds to the sense of community, et cetera.
Okay.
But then we also wanted to make it clear that we think there needed to be in new developments, some open space that was usable, that people could actually walk on and, not just look at from afar. So that's why we added these different types of open space.
Okay, good.
We have 5 categories, so
Mhm.
you covered everything.
All right. Barbara, did you have some other comments?
Just one more.
Okay, good.
And that was dropping the criteria to be considered for the planning committee, the expense to the city. If you put in a new development with 200 homes, what about schools? What about the hospital capacity? What about those kinds of issues? Did the BPW perhaps have input into whether or not expense to the city should be considered still in reviewing a subdivision plan? That one I wasn't quite sure should be dropped.
I'm going to ask Glenn to address this because we had quite a discussion on this. And part of the issue has to do with zoning and property rights of people if they own land that is zoned a certain way and that permits a certain level of development. So.
So this gets to an issue of
I'll let the
constitutional
lawyer-
exacts, yeah, right? This gets to an issue of what are called constitutional exactions. So you're taking something from somebody without good reason. So typically the law is if your land is zoned a certain way and under the zoning code, you're allowed to develop it a certain way, there should be an avenue to an approval. You can still put those conditions. If you recognize that this particular development is going to cause specific, a increase in traffic or somehow a larger impact on schools than some other typical development would, then through the conditioning the application process, you can require those sorts of conditions. But a judge or in a court's going to say, what criteria did you use to come to that number that you're requiring this developer to pay or to, this other thing you're requiring them to do that isn't spelled out specifically in the code that has some quantifiable relationship between the development and whatever you think that the developer should do. So that process, I think, should be left to the conditioning. When you're conditioning an application on something, when you recognize that it's going to have a larger impact on tree canopy, then maybe you can, in that instance, say we're going to require some amount of money so we can plant trees some other area to recognize the canopy that we're losing due to this development. But to put it in the code specifically that if you develop property, this much acreage, you will, this is something that you're required to do. Those cases are harder to win than a case that you've thoughtfully said, here's the impact of this development. Now we're going to condition it on these certain, with these certain conditions to address those concerns.
Okay, I was thinking more infrastructure kind of issues, If you've got a huge influx of population, can the infrastructure in the city bear it? And if it
Yeah,
can't,
so I can
should it
speak to that.
go?
When we did address it in the code, especially for the sewer, water and streets, we require a traffic operational analysis if there's a certain number of trips per day expected from the development. So that would look at the downstream effects of traffic. And then also we have in there, if you read it closely under the sewer and water sections, the board has everything modeled for sewer and water. And it's easy to input 100 homes at 250 gallons per day into that model and see what it does to the downstream system, sewer wise or water system wise. And it's written into this code that the developer will be required to make those improvements. Yeah.
Or obtain a letter from the BPW that they were available.
Yeah, and just by the way, we codified it. It's always been that way.
Right.
We've always done it that way. We've required developers to do that.
Barbara, thank you for your questions. Anyone else in the room care to comment? Yeah, Tom.
Continental 125 Washington Avenue. I'm speaking not as BPW, I'm speaking as a full member of Planning Commission. The discussion on definitions is something that has been around for a long time. Kay Carnahan was leading the effort about 5 years ago, because the problem is that we have different words defined differently in every section of the code. And what we thought was going to be a relatively reasonable effort turned into, I think Kay's got 10 or 12 pages of the various documents. Now, we got inundated with developments coming through and other things, and it got put on the back burner. But the discussion about open space is just the tip of the iceberg on the fact that multiple sections have different definitions or intonations, or maybe it's the same definition, but different words, which subjects it. So I think once things settle down, it's something that Planning Commission probably needs to take back up. But I recognize, and I think Nancy's done a yeoman's effort on this. So thank you very much.
Thanks, Tom.
Thanks, Tom.
As I think back on the open space permanent, I think that actually came out of Nina Kanata's suggestion when we were looking at the canal frontage along Pilot Town Road. And that goes back a good 10 years. So anyway, other questions from, yes, Donna, Dave. Come up.
Good evening. My name is David Ennis, and I've been an absent without permission for a number of years, and I apologize to the council.
No apologies needed.
I had a concern at the time I was last here, which I'd like to bring up under the new revision that's underway, and council may help me in learning whether this is an inappropriate place to say this or whether it needs to be added someplace else in the code. I live on 50 Harborview Road, but I was very active with a number of residents relating to New Road. As we all know, New Road has undergone some changes in the last few years that many of us have wondered about and worried about. At the time that the Brittingham property was placed into consideration for development, it's my understanding that a letter was sent to the city by the former director of the Division of Historic and Cultural Affairs, in which he advised the city of Lewis that there were known burial sites that had been pulled up in the 60s, I believe it was, and were sent to the Smithsonian Institute. I have a deep concern that there was absolutely no follow-up by the city of Lewis in investigating. And at the time that letter was sent, I believe there was an illustrative map of the plotting of the houses with a red dot that showed that future sites might also have been burial sites. Having brought that up, I feel that if this is an issue that has not been put in the code of the new draft, it may be something you'd want to consider. As a backdrop, one of the most impressive things to me was that the Groom Church property, a little further out of town in the county jurisdiction, Sussex County required the developer of those houses to do an archaeological study.
Right.
At this point, I just feel that the city of Lewis, while you're newly developing, ought not to lose the track of the subject of archaeological review.
Good point.
I'm just going to point out that was actually, if you had, was one of the questions we asked the public if they were interested in, if we should continue moving forward as part of the comp plan update to make that one of the the new recommendations from the 5-year review, because that was something we asked the people, like, should we require this as part of a study? So we are actually looking at that as part of the comp plan process.
That is a good point, because we had the information that Dan provided, but to my knowledge, there was no additional exploration done.
Right.
So
So can I ask a question about that? I mean, for anybody, I mean, so an archaeological review, what does that entail? Is that research? Is that a technology that's gonna determine if there's something underneath the ground? I mean, what does that mean?
So, for instance, we had to do it when we did the Highland Acres Water and Sewer Extension because
Okay.
it's in a similar vicinity. And it's just hiring an archaeological professional consultant, and they come out there and actually dig holes, and they get a representative sample of the area in question. It's not like they're digging 1,000 holes, but they get a representative sample.
To
and-
see if something's there.
Yeah, and I know when we did that project, they did come across like pieces of ceramic and other like things that were probably left over from American Indians, but
Mhm.
they were of such, there were so few of them, and little relevance isn't the right word, but that's the way he said it. You know, he said it's not relevant enough to make, like, to hold up the project or something like that.
So they actually just dig holes.
that was federal
Yeah.
funds, right?
Yeah, there were federal
So
funds.
that-
there, yeah.
The Highland Acres Sewer Project, they used federal funding, and when there's federal funding, you have to do the archaeological.
Yeah.
Oh, I see.
But I think you did bring up a good point, because there was not
Mhm.
any additional exploration
Mhm.
that I'm aware of, and I feel like I would remember it.
You guys know this way better than me, but if a subdivision makes its way to the state planning office, the historical and cultural affairs department of the state will get involved, and they have all that data. I know we don't have all the data of, cemeteries and burial sites and
Right.
things.
And that is something that if there's a concern that comes up, that the planning commission and/or mayor and council can
Can
ask at time of preliminary plan. So again, like any other study, if that does come up, that is something that can be requested, and then they'd have to go get that report before it would move forward.
Right, but Mr. Ennis's suggestion here is that we actually include language in chapter 170
Yes,
to
understood.
that effect.
Yeah, that's
Right,
understood.
okay, thank you.
And that can be done with ground penetrating radar as well, because the GLF just commissioned the St. George's Cemetery on Pilot Town Road, where that's how they identified that there are probably 500 graves there.
That's for graves. Does
That's-
that work for archaeology?
I think it would work for anything ceramic.
Yeah.
Yeah.
It all depends.
It depends.
It's
That
another,
was my
it's
question.
another tool in the
What do we
toolbox.
use to determine that?
Right. Good point, Dave.
I'm a little remiss in not expressing my appreciation to the members of the subcommittee of the planning council, because that was an extraordinarily good presentation. And obviously I could figure out how much work it went into that. That was a very impressive presentation. And thank you all for that very, very much. As you folks have been bringing up the discussion, I may introduce myself a little further, if I may, and that is that Ted and I have been facing each other for a number of years, but there are a lot of new faces. I have had 24 years in the General Assembly of the Delaware House of Representatives, so I'm a little familiar with the state nuisance that we can be and the solution they can be. But I would like to say that the discussion about plus and the fact that the Historic and Planning Commission do participate in the plus meeting, I think is important. And it ought to my way of thinking, that the evaluation of archaeology should be a part of the first town in the first state that has built its presence on history. The next point I'd like to bring up has to do with what I call flipping. It's my impression from the new road development that's underway today that the people who initially came before city to talk about the projects are not the people building the houses.
Right.
If that is a continuing trend, as I suspect it can be, I think there ought to be requirements within the city code to say the agreements that the first person makes or business makes have to carry over to anybody else that they sell. I don't know whether that's in there or not,
Oh, yeah.
but it seems to me there ought to be a binding relationship, some sort of a tail from those agreements that have been reached between the city staff and our planning department and the
Right.
developer who comes to you the first time, but they
Yes.
may change faces later down the road.
Right. So the conditions that are
They can-
placed on the development
Stay.
stay with that development. And I know, I mean, Janelle and I have been in meetings recently where the issue of changing some of those conditions has come up. And we are very clear that that cannot happen without coming back to the planning commission and city council to change those conditions.
I'm part of the problem because I am a transplant from Newcastle County, but I would like to remind you of one other thing, and that is, if I'm not mistaken, and I believe Janelle helped me with this, the city of Lewis in its current laws has a requirement that if you lose an approval for a project, you cannot come back for 1 year.
That's correct.
If I'm not mistaken,
Denial.
Newcastle County has a longer period of 3 years.
Right.
If there's a
It's a
denial,
review.
if like a change of zone is denied, you have to wait a year to
year.
come back with,
just a change of zone or is it?
that was in 197. It was not in 170. It's in 197, which is the change of zone. And I think the conditional uses and text amendments.
And I wasn't sure whether this is the proper portion of the city's code to think about extending that delay for a resubmittal. Now, I will also confess, having been a friend of some of the folks who worked very closely on the Rodney Road project that has now been approved, that if someone were to present a package to the city of Lewis and it is not approved, but the compliance of the non-approval process is in concert with their comp plan, which is a state requirement, it seems to me that there should be some legal protection of the city members and the council and the planning commission from litigation.
Amen.
I do not know whether it exists anywhere, but it seems to me that there's some kind of a umbrella of legal protection over members of council and the planning commission. And since that has come up, I may also just add to my comments that it's my understanding that the gentleman from the Historic and Cultural Affairs has submitted a similar letter on the property off of Rodney Road for identifying the fact that there had been archaeological findings of human remains on that property with a suggestion that there should be further evaluation done. And I understood that was not done either.
And that was for the Rodney.
Where?
Are we talking about
Fisher's
Fisher's Cove?
Is that what you're
Fisher's
speaking of?
Code, yes.
Okay, yeah.
I don't believe human remains are protected by state law. So if any excavation is happening and human remains are encountered, there's the Unmarked Human Remains Act that requires that all work stop
Right.
and that an archaeologist come in, and I don't know every step, but human remains are almost like the easier thing because that stops the
Stops
project.
everything.
It's the archaeological remains the archaeological sites that are at risk.
Yeah, and that did happen in Hawkeye. I'm aware of that, where there was human remains found.
Well, wherever you have the marshland and land along rivers, there tend to be
Great.
high likelihood of graves, but also just archaeological sites.
Sure.
Settlement
Right.
evidence. and stuff.
I'm sorry, but for clarity, are you suggesting that there has been reports that there were human remains or archaeological remains?
I have a letter that I received from Mr. Griffith that suggests that there were known remains found on the site there where that project was
I've
being
never seen
considered
that.
next to
Boy, I
Rock.
wish you had seen that.
Okay.
pretty sure it's on the website with the comments that were received.
And what was the
This is
date
Dan
of that
Griffith.
letter?
I'm gonna take a look, but where we keep all of the development reviews, when it went through the first time, I think I recall Mr. Griffith submitting a letter.
Okay. Huh. All right. While we're looking for that, Dave, do you have other things?
In one other focus, which is not necessarily on this rewrite, but I would like to share a piece of information that you folks may not all be familiar with.
Okay.
The state of Delaware in the year 2000 created a study called the Cost of Sprawl. It is on the state files of internet, and I have a quote I'd like to read from there that I think is significant. For the example, in the Northeast, the American Farmland Trust studies conducted in Connecticut, Massachusetts, and New York showed that $115 was spent on community services in residential areas compared with $1 of tax revenues generated by that land. Meanwhile, it goes on to say that the development of property for housing does not equal the revenue that you receive under your normal tax base. I would submit to you that if you continue to have further development in the jurisdiction of Lewis, you might want to consider referring to the cost of sprawl study that's in the state code to give you some background on whether it's a development that will result in good land, good money coming in, or higher expenses for you. And I think the previous speaker made some reference to the fact of the expenses going up.
Okay,
Thank you very much for your time.
thanks.
Thank
Dave.
you.
Thank you.
Anyone else in the room care to comment? Anyone else in the room care to comment? Do we have anything in the chat, Kayla? Nothing in the chat, okay? Okay. One more time, anyone else in the room or on the chat care to comment? Okay. Hearing none, I would suggest that this meeting has been recorded. And I would suggest that given the complexity of this, that we hold the comment period open for as long as possible. So I'm thinking that if we were to try and consider this for the 23rd, which would be the next meeting of the mayor and city council, that we should hold it open until at least noon on the 20th.
So I have a question on that.
Yes.
I think two of you at least said that you have detailed things that you may want to change. Should we have a special meeting for mayor and council to go through this? So that, I mean, because,
I think that could be a decision that's made at the meeting on the 23rd, if we
Okay.
put it on the agenda.
okay,
I think we need to get
Comment
public
period.
comment
Yeah.
from
okay,
as much as we can between now and the 20th. And council could decide on the 23rd that we want to hold another meeting yet to go back and work, take it section by section.
So you're suggesting the open comment period to the 23rd.
I'm suggesting the
To the
20th and
20th.
noon on the
Sorry.
20th.
I apologize.
Friday, May 20th at noon.
Right.
At noon.
Please send all comments to me,
Yes.
Janelle, the
Can
city
you
planner.
put-
I
can
will
you
put a
put a
comment.
comment? Okay,
I will put a comment form. And I think there's actually one on the subdivision code subcommittee webpage, but I will make sure we make it prominent. And if there's specific questions that council members may have, I'm happy to answer them. And I know Nancy would be happy to answer. So if there's a question, please just send them to us and we can provide a response.
don't
And,
forget.
and don't forget,
This one
we
too.
can get Charlie to answer some of them as well. So we'd be happy to do that.
And I'm sure that our subcommittee would be happy to help in any way we can in terms of facilitating discussion, because we, as a group, have spent a lot of time
Right.
going through each of these sections, and we can, happy to share with you how we
Right.
basically, ate it bite by bite. So
I think this is an amazing amount of work that needs
It
careful
was
review.
excellent, Nancy. Thank you
And
so
it's-
much.
It's very helpful. As I said earlier, we already have received 3 comments. One of them is from the Board of Public Works. So they have some questions coming in as well. So I think it may well be on the 23rd that council would decide that we want to hold a special meeting rather than try to make any kind of a decision that evening.
Mhm, mhm.
I mean, I really think that the complexity of this and the amount of work that's gone into it, it warrants very careful consideration and input from the public. So anything else to bring forward this evening? I would just comment that there were over 500 bicyclists who came to town today and on the police unity tour as they got off the ferry. So if you've seen a lot of police uniforms running around on bicycles, they're all moving through as they work their way to DC in rather inclement weather on their bikes.
Mhm.
So they will be departing from Troop 7 on tomorrow morning at 7 o'clock. So anyway, if there's nothing further to bring forward, I would entertain the motion to adjourn.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Thank you all for coming out tonight,
Thank you.
and we will
Thank you.
continue.